Hello. Hello, everyone. Thank you so much for being a part of this session. I am Aarti Srinivasan, and I will be the host for this session, where our two guests, Akshay and Girish, will discuss what every SaaS founder must know about data privacy. We'll get to know the importance of data security laws, the difference between a law and a regulation, tips and tricks that companies can use to become compliant, and how to navigate security challenges in remote workspaces. With that being said, let me bring our two guests on stage. Girish, you can just join in. Okay, and we're all set. We have with us Girish Redekar, co-founder of Sprinto and a leading expert in SOC 2 and ISO 27001 compliance for SaaS brands. He's a passionate programmer and entrepreneur who's keen on helping other SaaS businesses demonstrate security chops to close enterprise deals faster. And we have Akshaya Suresh. She's a partner at Commercial Law Advisors and has over 14 years of experience on transactions, mergers and acquisitions, technology laws, privacy and data security, corporate and commercial contracts, and corporate social responsibility. In short, there can't be two better people to tackle a subject like data security. Welcome, you two.
Thanks for having me.
Thank you, Aarti.
Okay, so I'm going to get right to the questions. So buckle up. So my first understanding is that there is a compound growth rate of around 18%, and with like more SaaS companies being favored by VCs, and all of them announcing huge funding rounds, it's no doubt that SaaS is booming, especially in 2022. So in that context, why is privacy and data protection so important today? Actually, you
Okay,
want to take it?
sure. When we talk about SaaS, the most important property your customer is sharing with you is their data. So it is important for them to know how you are going to process this data, which means how you're going to collect it, what you're going to use it for, how you're storing it, with whom are you sharing with, how long are you retaining it, and other such questions, which we call data privacy. What is also important for them to know is how are you protecting this data that the customer is transmitting to you when using your product, which is the data security aspect of it. So this is as far as customers are concerned. Separately, every company would have operations across the globe. So you would also be collecting a lot of data for your own purpose. For example, you would be collecting data for sales and marketing, for community engagement. You could be collecting data of your employees for HR purposes. So you would also be collecting a data of your own. uh, when you are collecting data, all this data that you collect, personal data that you collect, is regulated by laws across the globe. So when there is improper use of data or when there's data breach, not only does it affect your credibility with your customer, but it may also invite government action or hefty fines and penalties. Uh, this is the reason it's so important to pay attention to privacy and data protection and understand what are the legal requirements around it.
Okay, that's from the legal side of things. And Girish, your take on it?
So I think Akshay actually covered like a large part of what's important over here. But I have a little bit of a business lens to this. And SaaS fundamentally means that my data is on your servers, and like Akshay mentioned, we are fundamentally just sharing this data. But eventually, I need some assurance that my SaaS vendor, is keeping my data safe and secure. Now, so if you think of it from this lens, it's no wonder that compliance like SOC 2 or GDPR, they start becoming important hurdles to cross, especially when you're talking with companies who take their own data security very seriously, which is typically, you're talking about enterprise deals over here. And the important thing to note here is that these are hurdles that you need to cross. No matter how good your product is or how strong your value prop is, you still have to follow this cross this hurdle. Some cases this is just a requirement from your buyer. In some cases it's the law of the land, so there is no way you're escaping this, right? And the other thing to understand is that many of these compliances, like SOC 2 or ISO or GDPR or any of these things, they're inherently transitive in nature, which means that if a company is compliant, it needs to make sure that its vendors with whom it shares critical data, they are compliant as well. So these things are being passed on to you as a result of them trying to be compliant themselves. So to your point, SaaS is growing, but when you are actually trying to crack some of these important deals, these high value deals, it is important for you to be able to be proactive about it and not wait until the last point till this becomes a deal breaker. So you have to be compliant before you're actually getting into these deals. So that's my take on it roughly.
Sounds good. That takes me to my next question. This is where I'd like both of you to think hypothetically. I'm going to call myself an owner of a SaaS company, and I've been working in the US side. I've got my SOC 2 certification. Things are looking good. I've shown my ability to handle customer data, and now I've set my eyes on EU. And how close am I to getting GDPR compliant? And if do I even need GDPR compliant, considering both of them are about protecting customer data, and I've already shown that I'm more than capable of handling it? What do I do as a SaaS owner?
Okay. So often certifications like ISO 27001 or SOC 2 is bunched with laws like GDPR or CCPA under the umbrella of compliance. So both are spoken about in the same breath. Now, there are some overlaps between certifications and the laws that you have to comply with, but there are also some differences. So we need to understand what is the overlap and what is the difference. Now, every law that we know around privacy and data protection, be it GDPR or CCPA or the Indian SPDI, they would speak about in in the legislation protecting personal data that you process. So it would say that you need to have appropriate technical measures, you need to have adequate technical or organization measures, you need to have safety, you need to have security safeguards. These laws typically would not prescribe what those measures are. It will not go into detail what these are. So this is where a certification like ISO or SOC 2 would help. It would help in demonstrating what are the security measures that you have in place and that it has been verified by an independent auditor. And therefore, you can say I have appropriate or adequate technical safeguards in place. As part of these exercise, you would also be categorizing and doing an inventory of your data of information assets, which is largely the starting point for even compliance with laws. Having said that, certifications are best practices. They are administered by independent auditors and organizations, and therefore they are voluntary. A company need not necessarily or mandatorily have a certification. So, not only is the decision of having a certification voluntary, also the scope of it. What are the practices that you choose to adopt? What do you choose to implement? What is the scope against which you want to be audited? This is also something you have control over in a certification. A law, on the other hand, like GDPR or CCPA or the Indian SPDI or the upcoming data protection bill, these are laws of the land, which means they apply to you whether you like it or not. It is mandatory. You cannot pick and choose what in it applies to me, what can I comply, to what extent can I comply with it. It's not an option, it is mandatory. You have to comply with it. Uh, this is the difference between a certification and a law. So, to answer your question, when you have a certification, it does help you in demonstrating certain things required by law, like security measures. But what a law mandates on privacy and data protection is wider than what a certification covers. For example, a certification may not address things like subject access request, uh, uh, how are you addressing requests for access, deletion, rectification, portability, retention. How are you addressing data transfer? What are you using to legitimize data transfer? What are the contractual measures you're using? So these are some things that a law would explore, and a certification may not really explore that. And what the law would address, the scope is wider than a certification. So having a certification does not automatically mean that you comply with it. It just means you have a starting point against which you can assess yourself on what more is needed for me to comply with GDPR, and you can go ahead and do it.
Okay. So, like, I have just put up a poll for our audience to see whether the SOC 2 certification is a law or just a certification. Yes, most of you are right. Yes, it is not a law. In fact, it's a certification. So, you can calmly say that, yeah, we certify to this, but then the law comes to you and tells you there are certain things that you have not complied and you can't escape it. So, Girish, what do you have to tell about, as a SaaS founder, what do you think? How do you think the difference between certification and law comes to play?
Yeah, I think Akshay, sort of hit the nail at the center of the issue. One of the important things for us is that like you do SOC 2 in order to sort of mm, it's like an ease of doing business thing primarily. There are other reasons why you might do it, but it's a voluntary choice that you make given the realities of your business. However, there is no escaping GDPR or CCPA if you are actually if those laws are applicable to you. So you need to follow the laws of the land. But I think you're also asking in terms of what do I need to do over and above, let's say, SOC 2, if I want to become GDPR compliant. And from that perspective, I think the important thing, and I think Akshay also passingly mentioned this, the way to think about SOC 2 and ISO is that these are broad and general purpose security frameworks. They give you like a strong foundation on top of which you can build out more specific security or compliance programs like GDPR, like CCP, etc. So to give you an idea, a security program is typically designed to secure, let's say, customer data that's been shared with you, whereas a GDPR program is designed to protect privacy of the PII data, which is personally identifiable data, which is shared with you. So one of the things that you will do additionally is you'll sit down and look a little bit closely at the kind of PII that you are actually processing as a company, who gets access to it, what other vendors or subsystems are is that access flowing to, and then there is a bunch of things that you follow on from there on. But like Akshay mentioned, there is what happens as a result of it being a more specific thing, and its requirements being a lot more specific. Your additional there are a bunch of incremental things that you will need to do here. Now they get into technical stuff, like in GDPR you have things like a roster of processing activities or ROPA and things like that. Like, I don't want to get into the details of all of this, but neither can somebody say that okay, 70% of GDPR is covered in SOC 2. So the reality is unfortunately somewhere in between these two things. You can think of SOC 2 and ISO as a base framework. It's always good to have this in place before you can go to GDPR. Even if you go to GDPR directly, what you would end up implementing is a bunch of things which overlaps highly with the SOC 2 or an ISO program. So that's a simple way I look at this. This is like a foundational layer, and then you can build more specialized privacy or security programs on top of these.
Okay. All right. So it's basically like you do a gap analysis after you get your SOC 2 to see what am I missing before I'm GDP
Yes.
compliant.
Yes.
Okay. All right. So, what I've understood in the last few years is also that the term international business is no longer a goal, it's a state of life. Every single company, almost all of them, have clients abroad, are working on different time zones and across different countries. So, with that being the reality, how can organizations make sure that they're not just compliant with one particular framework that's based in their country, but also with the international best practices and standards? What can they do to implement on a daily basis to make sure that they're compliant overall?
Akshay, you want to take that first?
Sure. So when you have operations across the globe, or when you have employees across the globe, when different laws apply to you, a good place to start will be to have a privacy by design framework. So, what do I mean by that? It means I identify elements in a privacy program. For example, what are the policies I need to have in place? What are the agreements I need to have in place? What are the SOPs I need to have in place? What is the data retention requirement I need to have in place? So you would identify elements of a typical privacy program, and you will try to identify what fits best for your organization. That's where I would start as a privacy framework. And of course, you would need to map or measure, assess these individual requirements with every law that applies to you. But what having a framework would help with is it gives a template, it gives a starting point. You already know as an organization, this is something I want to do. So you just want to then go and check under those particular laws, do I need to do something more or am I good with it?
Hmm.
That is how I'd approach it.
Okay, that's from a legal POV. Some ideas, right? Like, but like I wanted to know, Girish, as in a practical application, what would be certain processes or best practices that uh, you can implement in a company that shows that you're capable of handling data and you're capable of uh, taking taking for these data privacy measures.
Right. So, my original idea of security, at least before we started doing something in the security space, was that this is a lot of this is about like a cat and mouse game between trying to stop attacks and using bleeding edge technology that stops hacks and protects your systems, etc. What I've really learned, having worked with like hundreds of companies now who and like building security programs from there, is that a lot more of security is actually around discipline and process around important activities that you do continuously as a company. This includes commonsensical things if you really think about them, like how you onboard employees, how you offboard employees. You have basic checklists in place around the way you push code to your production, how certain processes are managed, like how security holes get fixed in your company. So there's a lot more work around creating regular repeatable processes that you run as a discipline than around buying the best and the bleeding edge technologies that are going to sort of keep you away from harm. That's actually not how security works, and this was a revelation to me. So I'm just sharing it because I hope it's useful for many people who are going through the security route for the first time or a compliance route for the first time. In fact, if you look at most of the compliance programs, they a lot of their focus is around practices and processes rather than tools and services that you would use to make yourself secure. To give you like a simple example, it's a good practice, for example, to do like a periodic vulnerability scan, and whatever vulnerabilities are found in the process, you should have some internal way to fix them in a certain amount of time depending on the severity of those vulnerabilities. This sounds like a commonsensical thing to do, but just the fact that you do this periodically and you do it like you have a process not just to find vulnerabilities. It's easy to stop at that point, but to actually go ahead and fix the vulnerabilities that are found within SLAs that you set for yourself, that's like a good practice to have. It's good practice to have a checklist for every time an employee leaves your company. Hey, whether you remove their access from critical systems, whether you're making sure that certain basic things are being followed when employees leave your company or when employees join your company, etc. A large number of such processes and practices leave you in a lot better shape as a company when you're actually formally implementing a framework like SOC 2 or ISO, even if you're doing later. So, like you said, the most of the international best practices and the industry best practices are around following these practices and processes. Engineering teams tend to be typically good around following practices and processes around best engineering practices, but you can extend it to other operational aspects of your company as well, and that helps a lot.
Okay. Sounds good. I like the fact that you mentioned more about there being consistent practices than like something really cool like a cat and mouse hacking game that happens. I mean, slightly reduces the fantasy that you have about all of these
Yes.
hacking, but the reality of it is that, as you're saying, security is much more simple than what they make it to be. So
Yes, and it's rather boring that way.
yeah. So yeah, well, that also takes me to my next question, which is new challenges that comes up when business environments keep changing. One thing that has happened post COVID and now has become quite the norm is that almost all companies are working fully remotely, or even the startups, big companies have decided to completely shift to a hybrid model or fully remote model. So I mean, considering that this has been of the practice very recently, some new unexpected challenges has arisen, especially in the security space. So, what are those challenges, and how can companies tackle them?
Right. So I would slightly refine that and saying not all of them are challenges. Some things became easier as a result of you being, remote from a at least a compliance standpoint. I'm not sure if necessarily from a security standpoint. So to give you an idea, one of the constant things that used to happen with compliance auditors when companies used to be co-located, before the pandemic, is about how much security do you need to have around your physical office premises. This was it could get stretched to things like, hey, you need to have fire drills in your company, and hey, you need to make sure there's video surveillance on, and you need to make sure that you have AC maintenance contracts. And there are horror stories around these things. And I've seen founders argue that, hey, we are a cloud hosted company, there is no data on my premises, why are you asking me to do all of these things? Like, there is no data that ever touches my premises, so what's really going on over here? And this was like it used to be a debate. So one of the things that really happened is that once for a couple of years, pretty much every cloud hosted company, SaaS company, went remote. And as a compliance auditor, when you're trying to look at these environments, there is no office, like there is no sense in auditing anything around the office. So what are you really doing? And it sort of started happening is that people started tracking really where data flows, rather than just sort of lazily applying older models where, hey, office premises need to be protected in a certain manner, etc. So specifically what happened as a result of remote working is a lot more focus started going on to what is technically called endpoints, which fundamentally means all our staff laptops, like about securing them rather than securing the office itself, because no longer anybody is working in office, and you could be working from a home or a coffee shop or an airport, and it doesn't matter. And so that started happening. So I think the biggest change that I see is that there is a lot more focus on making sure that, hey, are your employee laptops encrypted, which means that if a laptop gets lost or stolen, and if somebody gets access to your hard disk, can they get access to something sensitive? So that becomes an important concern. People started looking more closely at, is an employee laptop always having like a screen lock on it, so that if I accidentally leave my laptop open and I walk away, and somebody cannot get access to my machine. And like I said earlier, like, security is rather about these boring things. Like, it's not about some cutting edge thing. It's the large security hacks sometimes happen because, yeah, your laptop wasn't locked, somebody got access to it, and then now they can do whatever it is that you would be able to do. Or stuff like, is your OS updated, and so on and so forth. So what really started happening is that the focus moved to where data actually flows, which is, let's say, your employee laptops and the systems that they access, rather than the proxies for where data used to flow, which is your office premises, etc. So that's one huge shift that I'm seeing as companies have moved remote. And this has become, in a very short amount of time, this has become like the new normal, so to speak, where nobody really cares about your office premises as a part of your security program, unless you really have servers on your offices, which is increasingly rare for SaaS companies. But that is a big shift that I saw.
Okay. That's quite interesting that, like, the laptop idea, considering all employees are very happy that they can work anywhere, the workation, staycation, all of that, and now to understand that there is like a whole security point to it. That's quite interesting to know. Actually, like, when I had this question that came in my mind when we were talking about employees working in across different time zones and different areas. How does how does law come into place when we have employees? Let's say one employee is based in India, another is based in Germany, and another is in Australia. Like, so how does that affect in a remote workspace? How does security laws come to place there?
Okay. So mostly the laws that apply to employee rights or employee entitlements, privacy and data protection of employee data, they all depend on the state or the country in which the employee is. So when it was a co-located office, when it was physical office, you would have all the employees gathered in one location, in one country or one state, and it would be easy to formulate an HR policy for them.
Mhm.
But now with remote working, they are spread across different states in India, they're spread across different countries. Now, because they are spread across different countries, you would now need to check your HR policy to see whether your HR policy complies with the laws in these different countries. For example, let's say you had your entire team in UK, and doing a criminal background check was just part of the background verification that you did. But now you don't have the employees co-located in UK, but they are in France. Let's take the example, they're in France. And France says there is really no legal basis to do a criminal verification check. So have you changed your verification policy accordingly?
Hmm.
Uh, EU gives a lot of rights to individuals, including employees. Employees can ask their employer for access to the data that is held, erasure, or raise questions and object to processing. But if they are now in Australia, they wouldn't have that right. So, are you giving more than what is required? Have you checked the different locations your team is in now and what is required under that? That is a challenge, and adopting this HR policy is important. Harmonizing it for this new normal, that becomes important.
All right. Speaking of new normal, for those of you who do not know, I'll give you a brief understanding. India is coming up with its own data privacy bill, um, which I'm just paraphrasing it. It's like what GDPR will is to the EU. So we have all of us. This will change the way the SaaS ecosystem works in India. I mean, that's the opinion, but we have two experts over here who will tell us more about it. So, Akshaya, what is it that companies now need to look out for when with this new law coming up, and how do we get stay ahead of it, and how do we prepare for it?
Sure. It is going to become quite important because India generates a large amount of data. If you go by the recent Joint Parliamentary Committee report, it's some 150 exabytes of data is generated in India annually. So when there is a law to regulate all this, it will have a significant impact on companies doing business in India as well as Indian companies. And you're absolutely right. It will be like the GDPR for India, and a lot of its principles are similar to what is under GDPR. But there are also quite a few areas where India is taking a different stand. It's approaching it quite differently. For example, India wants to regulate both personal and non personal data on the same footing, which is not really the norm under other acts like GDPR. India is viewing both as equally important and saying there's not much distinction that can be drawn. So, what companies have to start looking at is we need to have adequate technical measures, security measures to protect not just PII, but also other data derived from this PII. Another thing that would become important is how are you using derived data or de-identified data or aggregate data. Now, a lot of data sets are created from personal data for analytics, machine learning, a lot of different these purposes. And when data is de-identified, when personal data is de-identified, usually it falls outside the purview of the law GDPR. So companies would not really worry that much about it. But now with India saying no, we are looking to regulate both, you also need to start paying attention to what are you using these data sets for, non-personal data. How are you using it? Are you using it in a way that will affect a community through targeted advertising or suggesting some products? Is it going to have an impact even though it's non-personal data? So that is something companies need to start looking into. Another very, very important principle that India is looking at is data sovereignty and data localization. It already exists in India in some form. Payment and settlement transactions data need to be stored in India per the RBI mandate. So it's already there in some form. But what India is looking to do through the Data Protection Act is to expand this requirement to other kinds of data as well. So I presume that health data or biometric data, different other kinds of data may now be required to be localized in India. And the government is viewing this not just from a security or a law enforcement perspective, but also an economic perspective, because storing data in India is going to create jobs, it's going to create revenue. So they're quite serious about it. And I would start looking at where am I storing data of my Indian users or Indian customers, and I would start thinking about data localization. Uh, there are also certain rights that India wants to give to individuals, which are slightly different than in other countries. For example, they want to give the right to an individual to receive information on the fairness of an algorithm if it's used to make a decision in respect to the individual. So, what this means is if you are a company dealing in AI or ML products, or if you're a company that uses products, makes decisions with the help of AI or ML, you need to start looking into, is are there any biases in the algorithm? Is there something that I need to correct? Because at some point in the future, individuals can come and ask me, what is this algorithm? Do you think it's fair? And I should be able to answer it. So that is something again I would focus on. And India places a little more importance on bureaucratic requirements. So of course the bill talks about having an annual audit by an independent auditor like a financial audit, and having a mandatory DPO for certain kinds of organizations. So I would already start preparing for it. I will already get used to undergoing a data audit, so that when the bill becomes the law, I don't have much problem in adapting to it. So for India, the a good way to approach it is, we know what principles Indian government is looking at. So I would start building a privacy framework for India, so that when the bill finally becomes an act, when it's finally passed by the parliament, you already have a starting point. You're not starting from zero. You're already used to certain things, and you would just need to fine tune it when the DPA comes out with regulations and guidelines. And it will also give you a competitive advantage if you're able to move to compliance quicker. It also gives you a competitive edge in the market. So I would look at privacy framework for India, and not just in this, because India is looking at data as an economic asset. It recognizes that yes, personal data is a personal asset of the individual, but it's also looking at it as an economic asset for the country and for the community. So they are looking at creating regulations that will drive innovation in India. So they are talking about private public partnerships, integrating data sets to help research and better target service delivery, and creating other environments to promote innovation. This is also something the government is really looking at. So, if you are already used to a privacy framework, and if you already have something voluntarily, you would be in a very good position to take advantage of these opportunities when the bill does get passed.
That's a very helpful and detailed understanding of what we have to be in lookout for. Girish, do you have any tips for like a SaaS founder who's in the cusp of understanding what this new bill can impact their company with? So any tips about that?
Um, yeah, happy to chat about it. Like the engineer in me, by the way, is like trembling right now at the idea of data localization, because that's one of the things that's harder to pull off. But yeah, like Akshaya mentioned, and to answer your question, Aarti, see from a business standpoint, it's important to understand that India is no longer a market that we ignore. Like the older slash playbook used to be to start selling to US or outside of India from day zero. And we increasingly seeing like a new crop of SaaS companies from the country who at least treat India as one of their important markets, and most of them are India first, which means you find your first customers over here. So if you sort of fast forward to a world where this data protection bill is a reality, then you, even to get your first customers, you need to be playing by these rules. And the important thing is to prepare for what that would really mean. The important thing that I would or the primary thing that I would lay out over here is that for Indian SaaS companies is that this is not something you can ignore. uh, India tends to be an important market, and it will become increasingly important as time goes on. It is one of the fastest growing markets in SaaS. It may not be the largest, but it is one of the fastest growing ones. So it's not something to ignore, and you ought to be prepared for it. There will be more details coming out, Akshay was mentioning, as this becomes closer and closer to reality of what the specifics of this law are going to be like. And we will get more clarity on how to go about it. But what this really means is that you can't just take your first whatever few dozens of customers that you will probably get in your network, etc., for granted. Even for them, you would have to basically go through these compliances, have like a privacy program in place which helps you meet this you meet these requirements and do what's necessary for that. So that's my lens to this. The new SaaS playbook is going to look at India as an important market. So uh, be prepared. Yeah, we'll figure out what exactly for and how exactly the specifics are yet to come. But Akshay gave us some insight into what some of the specifics might look like, especially around data localization and stuff like that. So yeah, it's good to be prepared for it.
Well said. So we have a question from our audience. How far ahead of the curve is India in terms of regulating non-personal data within the DP bill?
Akshay, you want to
Okay,
take that?
yeah, sure. Uh, so India already has a non-personal data framework in place, and so do certain other countries. But the fact that India is looking to treat it very similar to personal data is definitely different than what we are used to. So, in that sense, I would say India is ahead of the curve. But having a framework for non personal data is not something completely new.
Mhm.
It
Hmm.
exists. It's just that India is taking it a little bit further and saying, I am going to regulate it similar to personal data.
Okay. There's a follow-up question for that. Is mandatory sharing of non-personal data problematic more than progressive?
Uh, that's a very good question because there could be a situation where the government requires you to share some data sets you have. We do need to wait and see what form the bill takes finally. There could be an opportunity, and there could also be something that we are not happy about.
Mhm.
Uh, but there are enough checks and balances in India to ensure that a company or an individual is not uh, loaded unnecessarily, and there should still be a protection of an individual privacy, and companies should still have some leeway. All that will be taken care of, is my sense. So, both opportunity as well as a problem, we need to wait to see which side it falls on.
Girish, your take?
No, honestly, I don't have an opinion on it. About whether this sounds sort of goes into the zone of whether it is right or wrong and stuff like that. I'm yet to form an opinion on it. Like that's my honest answer.
I think that's the most honest there is, like to not having an opinion and saying that. Okay. Yeah. One more question is, what would be the implications for a digital health startup with this DP bill?
I think one of the main implications would be around data localization. That is my sense. And health data may need to be required to be stored only in India, possibly. Another one is there needs to be a security by design or a security privacy by design framework. We already have this in place because there's already a framework on digital health in India. It's not a law, it is not mandatory, but we know that the government is already thinking about, let's create an environment, let's create a framework through which there can be portability of health data, where there can be easy sharing of data between the hospitals, uh, looking very seriously at managing consent, looking very seriously about security. So all of this would become important for a health startup. How do you manage consent? How do you record consent? Where do you store data? How are you protecting data? Privacy by design, security by design.
Um, Another question is, a consent-driven framework is the basis of health in India. How is this different from the personal data protection, more so when digital literacy is very poor?
Yeah, consent in India is going to be a challenge. That is a good question, and India is looking at a consent-driven basis rather than other basis, because of the diversity in India, the language diversity, cultural diversity, the size. Getting this consent is going to be a little difficult. Having said that, when the bill becomes an act and when the Data Protection Authority is set up, it will look into other bases for collecting, using, and storing health data, storing any data. So I presume if something is going to be very difficult to operationalize,
Mhm.
if it's simply not going to be possible, I am sure the DPA will come out with guidelines to say, okay, this is doable, this is how we can do it, let's do this. So there may be other bases for processing health data.
Okay. Another question is, are there any storage-related services from the government of India? Uh, it's a little vague. Can you please elaborate on in relation to what? Um, okay, they are coming up with the follow up, and one more is, how is an analytics SaaS platform company with clients from multiple countries with their own data privacy law get impacted? And do you think any conflicting regulations will create challenges in client acquisition or retention?
Yeah, so especially on this point, I think we shouldn't put the cart before the horse. We
Mhm.
need to wait and see whether there will be any conflicts itself. Because the current draft of the bill, a large part of it is very similar to GDPR. The principles are very similar.
Mhm.
Um, a possible area of conflict could be on data storage. If the final act says that any data that is processed by an Indian company has to be in India, then obviously it's a conflict. Because what if you're an Indian company servicing customers in EU,
Mhm.
which again do not want data to be outside EU? So those conflicts may arise, uh, but there will be a way to solve it. We will need to wait for the specifics to see how it can be solved. But there will be a way to solve it because commerce is so important. I don't think there will be a situation where there are a lot of conflicts between the Indian law and the EU law, and companies just don't know what to do. That will not happen. There will be clarifications from the Data Protection Authority, which will be set up specifically for this purpose.
Okay. Uh, the previous question, there's some clarification. Not sure if this is like, so they say it's similar to S3 bucket. Are there any storage related services from the government of India?
Not that I'm aware of, uh, honestly. I don't think so.
Okay. I hope that answers your question. When you can reach out to the Sprinto team, we can help you with it in case something comes up. We'll just give you an update on the same. I think if there are any other questions, please feel free to ask. I've also shared a compliance playbook in the handout section. So if you can feel free to download that and have the takeaways from this webinar. And so yeah, that's about it from our side. Thank you so much, Akshay and Girish, for taking the time for this webinar. I hope the audience had a good understanding of the laws and regulations and what's to come and what's already there. And I hope you have a good understanding now, and I hope you take away some of their important philosophies that they talked about, and I hope you find that helpful. Thank you so much, everyone. And I hope everyone has a good day.
Thanks, Aarti.
Thank you.
Thank you.
Bye.
Bye.